Madam Chief Justice, members of the court, I would please plead with you to bear with me, but we do need you to clarify again what we are about to listen from my learned senior Paul Moite and my learned junior, one of my favorite pupils, Mr. Issa Mansour, is not the case that was not admitted. It is a response to your questions.
I thought we settled that.
We take offense to these lectures. We're in a court of law before the Supreme Court.
Let's leave
we
the
are not at the
we
university.
settled that. Please, senior counsel, are you the one taking the floor? Okay. Oh, it's Mr. Issa. Please take the floor.
The Honorable, the Chief Justice of the Republic of Kenya, the Honorable Deputy Chief Justice, and the Honorable members of this court. My name is Jotham Arua. I'm here to answer a specific question that was addressed to me by the Honorable Justice Lenaola. He had asked a question on behalf of the 4 commissioners. What were they doing at Bomas? We saw them reading some results. Was their walkout an afterthought? That's the question I will be answering, and after that I will cede the floor to my colleague Apple Lomboya, and thereafter Issa Mansour. Madam Chief Justice, the 4 commissioners have explained and clarified in their affidavits that they joined the commission in September last year. They soon found themselves having to operate in an environment in which all decisions were being made by the chair, who was operating apparently on the basis of a settled, firm, but fallacious conviction that all the executive authority of the commission reside in the chair. That heretical position was espoused in this court by none other than my teacher, Professor Githurano. But my teacher, however, forgot to explain to this court the particulars of the law which vests executive authority on the chairman, but does not do so on the commissioners. Madam Chief Justice, the 4 commissioners have explained that as early as April this year, there were already protests, verbal protests being exchanged as between them and the chairman. And they have annexed series of correspondences to that effect, which are annexed to the affidavit of Juliana Ciira, but I would leave that to be taken up by Ciira's lawyer, Mr. Apple Lomboya. Now, when they reached Bomas, they were assigned menial responsibilities, as this court has been told. Once again, there were protests, but the commissioners took the firm view that it would be responsible for them to let their infightings be made public for fear of eroding public confidence in IEBC during an election year. And it is for that reason that they chose to handle their differences diplomatically. Madam Chief Justice, these matters are contained in the affidavits. They have further clarified that although they were willing to tolerate corporate governance infractions with equanimity, they were not ready to do that with regards to serious constitutional violations. There is no doubt that they were not involved in the tallying or verification of results at Bomas. The only thing that they would do is that they would be given results sporadically at the absolute discretion of the chairman to read, which they did, sometimes with embarrassing consequences, as were explained by Paul Mwangi in the morning. But they could not stand it any longer, Madam Chief Justice, when they were now being asked to sanction results, and they were not being asked, given information that they needed before they could sanction such results. The four commissioners were quite clear that they had a role to play. And they were quite clear that the results would not be delivered unless and until the winner is proved to have received more than 50% plus 1%. 50% plus 1 of the votes. All they were asking for, Madam Chief Justice, was information that could satisfy them that such constitutional provisions had been complied with. But that was not forthcoming. Instead, their request was construed as an attempt to moderate the results, and that is what they could not stand. Madam Chief Justice and honorable members, at this point, allow me to call Apple Lumboya to come and explain exactly what kind of exchanges ensued earlier on between the four commissioners and the chairman. Thank you very much.
Your Ladyship, the Chief Justice and members of the court, the question that was asked, so that we are not accused of rehearsing a new case. The question that the court asked is that please show us that there were problems that was brewing. That's the question that the Honorable Justice Lenaola and the Deputy Chief Justice asked. Yeah, members of the court, if you look at the fifth respondent replying affidavit, Juliana Ciira, Annexure JC2 are memos. These memos are way back from April, when the chairman unilaterally caused the reshuffling and transferring of returning officers. And just to read one of 12th April of 2022, the three commissioners, that's Juliana Ciira, Justice Nyang'aya, and Francis Wanderi, says as follows, addressing the chairman: we are specifically addressing your direct role in blocking our participation in corporate decisions making on the area of policy and oversight in the context of staff deployment. In that annexure, there are several memos going back up to April. That is almost 4 or 5 months after the commissioners had joined. Because of lack of time, and the only request I want to make to this court on behalf of those gallant 4 commissioners is that in your decision, you'll find a paragraph to shower accolades on these 4 commissioners for blowing the whistle to the infraction to our constitution, and that the results that were read by the chairperson of the commission were dead on arrival. And since we have a self-confessed mortician in our midst, we will appropriately request that the funeral rites for those results that were announced be performed appropriately. I call upon my colleague Isa Mansour to take over.
Good afternoon, my Lady Chief Justice, the DCJ and judges of the Supreme Court. I'll very quickly go through the remaining questions asked by the judges. The first one, I think I'll combine them, and I'll just indicate who had asked these questions. The question by Justice Lenaola, whether the violence at Bomas affected the ability to announce the results of the 27 constituencies. The simple answer is no. My Lords, the position taken by the 4 commissioners is that there was opportunity, and as has been confirmed by my colleagues from the IEBC, to deliver those results in the morning. It was not taken, and the failure to announce those results in a respectful view triggered the scaffolds and the protests that you witnessed. The next question that had been asked by the Honorable Chief Justice and the Deputy Chief Justice is whether the Commission was dysfunctional, and at what point did the Commission stop functioning as a corporate entity. The simple answer has been explained by my learned seniors, but the correct position is the Commission continued acting as a corporate entity, but it had serious corporate governance issues. And this is confirmed by the fact that they were able to deliver a general election, they were able to train presiding officers, so the Commission continued working as a corporate entity with the Secretariat and the team behind it, but they had serious corporate governance issues that have played out in the proceedings before this court. The third question that has been asked by the Chief Justice is what steps were taken, and this is, you'll find in the replying affidavit of the Vice Chairperson of the Commission. As early as April, as my seniors have said, when these issues about deployment of the election managers and presiding officers was brought to the attention of, came to the attention of the commissioners, the matter was dealt with at plenary. And they wrote to the chairperson objecting and raising those issues and all the other issues, my Lady Chief Justice, that arose in the management of the affairs were dealt at plenary. The only problems you would note in their replying affidavits is that it's only when the chairperson took unilateral decisions in the name of the Commission, that's where the problem was. And this is set out in paragraph 8 of the Deputy Vice Chairperson's replying affidavit. You'll have time to look at it. The third question, and this is a question that was not answered, was directed at the IEBC. I waited for that answer, it didn't come. I had posed it the other day. Why was the public display of results stopped? When you look at the replying affidavits of these 4 commissioners, all say the same thing. That public display was stopped by the chairperson, and they requested him to resume the tallying, the display of the results, and he declined. What I was waiting for today was an answer from the chairperson as to why. That silence speaks volumes. The last question was the question that was asked by Justice, so that I can finish and give it to, by Justice Smokin Wanjala, Supreme Court Judge. Why were the numbers important, the turnout? There's a simple answer to this. The voter identification is biometric, and where that fails, it's by the kit. So, my Lord, the IEBC has a constitutional duty to put in mechanisms to ensure there's no electoral malpractice. When you go back to 138.4 to determine who has won the election, the voters that were biometrically identified, the KIMS kits are configured so that they keep sending the information, which Mahat was trying to explain today. When the numbers come in Form 34As, those numbers that are finally tabulated have to, because of the biometric voter identification, they must tally with the number of people who turned out to vote. So when you're looking at those, so when they give a percentage of the number of voters who voted, and you look at the tabulation in the final Form 34C, those numbers have to merge, and they have to make sense, including the Form 32As. That is why the turnout is critical. It gives transparency, and it helps to give credibility to the process. And that's why they have to tell the public, you have to know how many people are registered as voters, then you know the percentage of voter turnout, you calculate that, and then you can determine how many votes were cast, how many were rejected. All those numbers, when you compute them, they have to add up. When they don't, my lords, then there's a problem with that election. Thank you, and I think I will cede the ground to Senior Counsel to close it in the next 1 minute.
Very briefly, Honorable Chief Justice and members, Justices of the Supreme Court, on the issue of violence at Bomas and the impact and the character of these four commissioners. Let the record of this honorable court show the following: that at the time preceding their walking out, the posting of the results on the screen had ceased, had stopped. So all they wanted to know, these four commissioners, is to be given the opportunity to peruse the results of these 27 constituencies so as to satisfy themselves as to who the winner of the elections was, number one. And number two, whether that winner had reached the constitutional threshold of 50+1. That's all they wanted to know. When that was denied, they had no option but to refuse to be a party to the violation of the Constitution. So as I sit down, let this record of this honorable court show that the results that were announced, the declaration was not a declaration, just one. That declaration by the chair of the Electoral Commission was not a declaration of the commission. Therefore, they are the majority, they do not support it, they ask for nullification of that declaration. I thank you.
We'll go fast. Mr. Ngatia.
Madam CJ, I'll cede ground to the head, who was the former head of the bar, Attorney General, okay. Emeritus.
Okay.
Madam Chief Justice, members of the court.
My Lady Chief Justice, I have an objection to the... I have an objection to my learned senior's application, which he indicated earlier. My lady, we will of course be guided by your directions, but I rise to oppose the application by my learned senior, Mr. Gitu Muigai, to present evidence to controvert the submission by Julie Soweto. My Lord, my lady, the indication was that they'd been taken by surprise and should get a chance to present their view. They were not taken by surprise and can't be taken by surprise because...
My lady, if I may, this is a very awkward moment for me to interrupt the teacher who taught me procedure. I thought that one could only respond to an application that has been made, not before it is made.
Of course it has to be made before. The objection has to be made before.
Can I make the application now?
No, there's no point to it. He had indicated he was holding the application so that it has been indicated. So my objection is, and his own ground, that he needs to be replying to something that he had never known. That picture was taken from the portal of the IBC. So he's not taken by surprise because it's their own picture on their own portal, and it's still there now as we talk, as we object. But secondly, this is the first time in many years that I've ever seen a party asking to rebut their own evidence.
And that is an oxymoron that reflects accurately the state of their records. But I stand guided and would gladly withdraw my objection if the court wishes.
I think where we are coming from, Senior Counsel, our teacher, Mr. Firoz Noronji, is that when the two forms were displayed, they wanted to respond because they said it's new evidence. And you saw the bench resisted to begin with, but we went to the records to find out whether it is among the forms that were submitted here, especially in the affidavits of Dr. Celestine, Mr. Arnold, and we found actually it is new evidence. That's why we allowed them. It is not an objection. It's a clarification because they said this is new evidence that they had not seen before. It is in that context.
Much obliged.
Yes, yes. So 5 minutes.
All is well that ends well. Mr. Mahat will give the explanation. Thank you very much, my lady.
Your Ladyship, Madam Chief Justice, Deputy Chief Justice, and Associate Justice of Supreme Court, I wish to respond to 3 very quick issues that were raised by my learned colleague, Ms. Julie Soweto. The first one relates to a form that was shown this court. I will want the form to be projected. We will. Whatever that was projected from the portal, that is what we want the court to see. What Ms. Julie Soweto showed. You could go, please go to Jose Camargo. I want to produce to the court the original form 34A. Yes, you can see. It's okay. I want to produce the form 34A, the original form 34A, and I want to inform the court that the name Jose Camargo on that form is an overlay. Jose Camargo, the register of the QR code, that was printed by Smartmatic International, and it was printed in the name of Jose Camargo. You can show? The register is available.
We were very patient the way Mr. Muhammad addressed the court earlier. Very, very persuasive. But for good order and not to interfere with his submissions, we kept quiet. And if you look back at the record, a lot of what Mr. Mahat was saying was actually giving evidence. He was talking using the word we. This is how we do it. The trajectory which he is taking without a witness to tell us the kind of information he's going to give us is going to put the court in a very difficult position. I think he should transform himself to a witness and we begin to cross-examine him. Because, and this is very serious, either we practice law the way we understand the law, or anybody can confront the court with any document at any time. I understood Mrs. Soweto to be giving an explanation in response to a question by the court. And similarly, Mr. Muhammad was responding to question by the court. And therefore he had some latitude. But now we are entering a different universe where he is now going to produce evidence. He is saying how the picture was taken. There is no certificate, and this is electronic evidence accompanied by an original. I think it is very, very dangerous territory. And unless some clarity is given on this matter, it is going to be very difficult to operate from now.
My lords, what we are trying to do is to show you documents in our own affidavits in response to documents produced from the bar. Ms. Soweto never produced the document she showed you in any of her affidavits. When we now invite you to look at the original and to make the argument that my learned friend is about to make, that there is a deliberate misrepresentation of what the original document looked like. So we are treated to this attempt to block that fact from the court. This is not a legitimate objection. This is an attempt to interfere with legitimate evidence that is on record.
Okay. Let's give it directions, because we'll be here until tomorrow and we don't have this time. Senior Counsel.
Yeah, just one point. And I'm normally very quiet, and I continue to be very quiet. But the good professor has misunderstood Ms. Soweto completely. It is not this document which is in question. It's the way the interference is being done, how this document is changed to another document twice or three times. I think the good professor will be doing a good service to the court. And if he is good coming into court with clean hands, he should first of all say, Mrs. Soweto, what Mrs. Soweto showed us today is not in their portal. That is the starting point.
Isn't that exactly what
that is the starting point.
Bear with us, Senior Counsel. We've come thus far with a lot of discipline and dignity and respect to the court. The reason why we are here, and you saw us take a lot of time to reflect on the application that was made by, I think he started with Mr. Katwa, Keegan, Mr. Kirago, and Mr. Ngatia. We resisted until we established from the pleadings that we have that these are new forms, and indeed they are entitled to respond to them. So please, if you can just respond without taking us into anything else, just respond to those new forms, because they were not part of the ones that we have before us. We established that.
Thank you so much, Madam Chief Justice and members of the court. The difficulty we were facing in thinking about this, an allegation has been made as relates to this form, and there's an overlay of someone called Mr. Jose Camargo. What we were trying to show the court, that this is an overlay document, and we wanted to actually show the court where this document from Jose Camargo has come from. The document relating to Jose Camargo has come from the QR register, which is distributed to every polling station. And that document is even in the possession of this court. If you look at the scrutiny report, the QR documents are there. So what happened? Apio took an original Form 34A, he had the QR register, and he took a picture of it. What is the evidence that is being given in this court? That someone called Jose Camargo is interfering with this. And the point we want to make to this court is that if you look at the scrutiny report and if you look at the QR register, which is in those boxes, you will actually find the name of Jose Camargo on the register that has been printed. We've also produced the original Form 34A. We've come with the receipt. And we're being told that you cannot produce your original 34A, that Jose Camargo was interfering. And in fact, if you look at the numbers on the original 34A, it's the same as what the picture of the overlay was taken. So to the question that someone called Jose Camargo was interfering with the portal, it's actually not true. It's incorrect. And the attempt to prevent that evidence to the court should actually guide the court that actually that is not true. Why will anyone try to interfere with a portal transmitting, and the result he has is the same as what is in the A and what is in the portal? So to that question, we submit that that is not true, and that is an overlay that someone who has taken the picture. We will give the court the Form 34A to compare with the original 34A with the certified copy that the court has. And in fact, we direct the court to the scrutiny documents. That register of opening and closing the KIM is there, and the name of Jose Camargo for purposes of audit trail is printed in there. Smartmatic Jose Camargo is printed there. So what has happened? Someone appeared, took a picture on that one. The next point I want to make is the issue of the KIMs. We've been told there are 2 KIMs kit which had the same serial number, and we understood our role to this court to give all the information to the court to make a decision. We admit that those KIMs have the same serial number. It was an error that originated at the time of the serialization, but we want to tell the court that those KIMs have different IMEI, they have different IP addresses, they have different polling stations, they have different, so they have different identifiers. And we acknowledge that that is an error that originated relating to those 2 KIMs. But there are other identifiers that can identify those KIMs are from our system. And we want to give that information to the court for purposes. Those KIMs are on their way to this court. We will give to the registrar of the court for the court to analyze and to look at it. And if you look at those KIMs, they transmitted the forms as required in the portal, and the A's also are coming, the original A's we will also give for those 3 forms. And our role is to give. The issue of transmission has come up. I just want to say this. There were 3 sets of transmissions at Bomas. One on the forms that has been downloaded, that was running properly. The second one related to the constituencies, that was continuing. The one which had stopped was the one on the tally. And the reason it stopped was, for 3 days, we had only verified 50 arrows. The process became clogged. For you to be able to transmit to the announcement, verification had to happen, then announcement happens. That means that those arrows have to be stopped, because verification cannot happen as announcement is happening. We will be running numbers that have not been announced yet. So because of that, and because of the audit, forensic audit that most of the agents were recommending, we had to stop that process to give verification a chance. There was nothing malicious about that. With those few remarks, Your Ladyship, I stand guided. Thank you.
Mr. Mahat, maybe we can have a look at the
My lady,
original
if the
34 that you are showing.
Sorry, my lady, Chief Justice, if the form can be handed over to the court. Excuse me. A moment. Thank you. Thank you. My lady, my learned friend, Senior Counsel Murgor, has a comment after the court has seen the...
As you continue to look, we'd just like to make an observation. In fact, we are happy that the court receives the document, particularly the Form 34A, and everyone has been quoting Shakespeare and all the rest. I'll just quote some Swahili. Siku ya nyani kufa, miti yote huteleza. If you notice on the 34A, the UDA agent, the second agent, signed the form on the 7th of August 2022, before the election. Before the election. I repeat, before the election. The other one as well, perhaps might have signed it on the 7th, but it's not clear. So that's all we wish to say.
While at it, Counsel, just before you go back, and when did the other agent sign?
It looks like 7th, it looks like 9th. Only the IBC and Mr. Chebukati can tell us. It is their evidence.
Before they explain, they would have to have something to explain.
We have let it go in.
This form, from the naked eye, of course, appears to have been signed by both agents on the same date. And the same date is 07.
Oh, 07 of 08.
07 of 08.
Yes, indeed.
See, well, I thought the point you were making was that the second one signed before the election. As though the first one, if I could just finish.
Okay.
As though the first one had signed on a different date.
No, our point is, and has always been, these forms may have been manufactured elsewhere, before, well after voting, and they all arise one day and they are counted. It is the mess that is IBC, and it is the mess that is the 2022 presidential election that we have been emphasizing. Thank you.
You still want to talk?
Madam Chief Justice, my client is the one who is likely to suffer most in case these sensational matters are not dealt with effectively. Starting with the date, that is more of drama than reality, is seeing a speck in the other person's eye when the log is in the other person's eye. One of the things I think I ought to place on record is this. The forms that are now in issue have not been pleaded, were not tendered, and since they were not pleaded and they were not tendered, we should not be accused of not having responded to them. Point number 2, both agents have made a legitimate or have made an innocent mistake about the date. And I don't see where the laughter is emanating from. Point number 3, the form itself shows a contrary position to that which was sensationally displayed before this court. The sensational reporting that was made was intended to convey a picture which is to the opposite of what the form now before the court conveys. And that reminds me of that very unfortunate day in 2017 at 9 p.m. that again sensational claims were made about forms 34B from Mombasa, in particular Shangamwe, made also to this court, and which led to a nullification of a presidential contest. Madam CJ, there is also one more thing that concerns my client, because again, it has very prejudicial effect. It is what is definition of the commission. I will spend 1 or 2 minutes defining the various ways commission is defined in the law. Commission is first and foremost defined in Article 88. Commission is also defined.
Sorry, if we open the matter now to other things, we will not see an end to this. You were responding to the 2 forms which were introduced.
As new evidence.
Yes, please don't go to other things that you are not supposed to, because we will not see an end to this.
I still have my time.
With respect, even if you have your time.
For the governor,
even if you have your time.
Thank you.
Just deal with the 2 forms.
So then, coming back to the forms, my request is this. Please delete from the... yes, the other thing is that all the form now before you has security features. The one that was displayed does not have. The one that you have does not have the name of Jose Camargo. The one that was displayed before the court has that name of Jose Camargo. The original one you now have does not have that name. And all those things were meant to deceive. They were meant to mislead.
We should never have to ask that we remain the way we started. We should never have to ask that.
particularly from such eminent lawyers. The one that you have does not have any of those things that were displayed. My client therefore becomes quite concerned whether this case is to be adjudicated in the realm of falsehoods or within the parameters of factual contestations. That is a real concern. The minute we allow matters which are clearly false to infiltrate into the record of this court, we are likely to get into a very, very unfair decision. Let this case be decided on factual points and on factual contestations. We say the same about the second form, that the original has not been provided. But as regards the second one, allow me to say this: before this contest started, IEBC did avail to this honorable court all the forms 34As. All of them were deposited because we did see that correspondence. Consequently, as regards the second form, I would request this honorable court to find time to look for it, the certified copy, and in case once again it does not have this JAWS, whatever name it is, please come to this conclusion that a deliberate effort was made by counsel to mislead this court so as to arrive at a decision which would be most injurious to the first and second respondents. I'm very grateful for the 5 minutes, and I rest.
Thank you very much. With your permission, we would like to go to another segment of these proceedings, the last of them, where we'll be considering the report from the scrutiny or the discovery that was undertaken by the court, and I'll ask the Honorable Lady Justice Joaquin Dongo to take us through that session.
Thank you very much, Madam President Judge. Before I come to the issue of the exercise before us, I just wanted to assure Senior Counsel Paul Mwite that when the 14 days start running, and we are guided by Article 259, when we do work Saturdays and Sundays. So as soon as the time is triggered, in fact, the judges are working all the time. You're the ones who get to go home and rest. When you rest, we go and we continue to work. Thank you very much. So just before we proceed with the next session, it was just a summary of the order that we gave to parties and the rationale for those orders. We received 3 applications from 3 parties, from the Youth Advocacy Africa. We received an application from Khelef Khalifa, and we also received an application by Raila Odinga and Martha Karua, in which we were asked, the press was sought to undertake scrutiny and access to certain information. After we looked at the applications and the prayers, we then looked at the pleadings and the affidavits to ensure that the prayers matched with the pleadings and the affidavits that have been filed by the petitioners. As you will recall, the court then determined the issues which we will determine, and that also helped us set out the orders for scrutiny, so that our orders were set out based on the pleadings, the affidavits, the issues for determination. But further to that, we also did say in the body of our order that we would not encourage a fishing expedition, and that the request needed to be specific, and that given the 14-day timeline, the court would only allow reasonable, practical, and helpful orders. We also acknowledged that under Section 12 of the Supreme Court Act, the IEBC has already submitted all the Form 34As, and therefore they could be accessed in the court. We also stated that some other issues, some other things that had been requested for in the prayers are in the public domain, and that parties could then get those. We did note that some of the requests or the prayers were unrealistic. Some of them were general and vague. Some of them involved parties that were not enjoined to be before us. And therefore, we granted orders not based on prayers, but based on what we assessed that the court needed to look at in terms of all those criteria that I have set out. And therefore, the exercise that was conducted under the hand of the registrar followed strictly the orders which were given under the hand of this court using that criteria. I think that is a fair summary. Madam Judge President, I will stop there.
Thank you. I think an exercise was carried out, a very rigorous exercise led by our registrar. Indeed, these are people who had not slept for 24 hours working to carry out this exercise of ensuring that there is compliance with the orders of this court. Our staff actually spent a night here. They had to shower somewhere here and continue working yesterday morning. So the report has been shared with council online, and because the parties who are involved in the requests for the discovery is the main petitioner, the Youth for Advocacy, and the petitioner Karif. We have decided to allocate each one of you 15 minutes to submit on any issues you like us to take note of in the report. That is the main petitioner, 15 minutes. Youth Advocacy for Africa, 15 minutes. Karifa, 15 minutes. Then we will have IMBC, 15 minutes. And because the first respondent is also affected by what is being discussed in the report, we also agreed to give them 15 minutes. Yes, you have the floor.
Thank you very much, Your Ladyships and my Lord. I'll be as quick as possible, and I would like to indicate that I will share the time with my colleague Jackson Awele, who will deal with what happened at Forodha, while I will deal with everything that happened at IBC Anniversary Towers. The report the court has given runs into 178 pages, but we worked overnight to provide written observations to the court, which we filed this morning, and so all parties are actually aware of whatever it is the first and second respondents, petitioners have observed. Very quickly, IBC confirmed that the RTS, the results transmission system, runs on 8 servers of which one is a virtual server.
Council,
Yes?
you say you filed something?
Yes, we filed written observations with court, and we have a few copies.
Just wait until we get our copies. Are they in the bank?
We filed them
just
before.
give us
Okay.
a moment there. Yes, yes. If you say you have extra copies, you could give us? Yes. So as to save on time?
Yes,
we do not have a copy. If Learned Counsel could be kind enough and serve us a copy.
for the principal respondents, we can give you one of each.
This shows the time we are given to respond.
We served them before 9 o'clock this morning. Electronically. The only thing that there'll be a problem is some of the images will not be very clear, but when you do have time, the images at the end.
Just hold on, Council.
Okay.
You could start.
Yes, Jackson, you could also perhaps upload it so that those who don't have a copy can see where we're reading. I'll go to the first observation on page 2, summarize the first paragraph. IBC confirmed that the results transmission system runs on 8 servers, of which 1 is a virtual server, and the 7 are Docker containers, which is a server within a server. The IBC denied agents access to the Docker servers. We were therefore unable to proceed further with that exercise. Paragraph 2, the...
Council again.
Yes.
The copies you've given us are not filed.
They're not filed, the electronic ones are filed. I anticipated having to provide 1 or 2 people with copies, but the electronic ones are filed, very clear. We have a receipt.
Yeah. It's all right.
Okay.
Council, I think we had already given directions that we expect oral submissions.
I am making oral submissions.
Yes, so
Okay.
I'm just saying, let us not worry too much about written reports, who has served who.
Okay.
You're letting the court know what you think of the exercise so that we can take those submissions into consideration. And that should apply to all the other parties.
I stand guided, thank you very much. I go to paragraph, or I'll just make it an oral submission. The virtual image availed for scrutiny was created on the 31st of August 2022. We therefore state that this cannot be from the same server that ran the just concluded general election. And the image of the server was not provided. The further major observation we make, the KIMS kit was not availed for scrutiny to establish the availability of the embedded scanner application that would verify the image format. So the IBC declined to avail the system documentation. I go on. There was very disturbing evidence of log deletions from the IBC server that was availed, in part, partially availed. These deletions occurred on the 6th of August 2022, which is 2 days before the contested election. We observe that surprisingly the registrar's report at page 21, issue number 5, indicates that there were no deletions. We think this is a mistake. It should be looked into. The effect of the deletions, we can upload that. It's on the screen now, that we were able to get from IBC, indicates that, and this is image marked 15, that at the material time, foreigners, including Ogudino, Vito, J. Carmago, Josio were operating the system. Those are 5 foreign individuals. If a forensic image of the server is available, details of what was deleted would certainly be established. The other major observation, IBC refused to provide a security walkthrough to highlight key security controls to determine whether Form 34A could be tampered with during transmission at what point. So we hit a dead end, contrary to what their counsel repeatedly says. They are transparent, it's available, they are even giving the court, donating to the court KIMS kits to look through. Finally, or well, not finally, IBC refused to grant access to the forensically imaged servers. Instead, the server administrator projected the vSphere, which is the virtual server application management system, on the whiteboard to demonstrate the access to the servers. The vSphere indicates that the virtual RTS server was created and modified on the 31st of August at 2022. In effect, no information from a server was provided to show what happened during the 2022 general election. Number 11, a couple of manuals were provided, or bundles of documents. We'd like to point out that of interest to the court would be that at page 77 of one of the manuals titled Information and Communication Technology ICT Policy, at page 77 and 78 is a list of 77, a list of 41 individuals, starting with Dixon Kwanusu, and second one Abdi Dahir Abdi Malim, who are described at the top of the page as national returning officers, an office unknown to the law or the Constitution. I would request that the court takes note of that in particular. And paragraph 14, on the 1st of September 2022, the deadlock over the servers was finally came to a head when IBC wrote to the Registrar of the Supreme Court enclosing a letter dated 31st August 2022 from Smartmatic International BV, the same company that Carmago comes from, enclosing in which the letter states, amongst other reasons, the image of the NTC servers containing software owned and copyrighted by Smartmatic and thus IB protected. Providing full access would infringe our intellectual property rights. That brought to the end that matter. Smartmatic, Carmago, whoever they are, wherever they are from, have indicated that they will block and refuse access to the servers completely. I then move to the images. Certain images were shared by IBC. I'm not certain that they were aware of what they were serving. There was always staff that seemed quite unqualified in whatever they were doing. They couldn't operate the systems or pretended they couldn't, but they did share image number 6. The first image I showed was the image of deletions, but the one I would like to focus on in this very limited time is image number 6, which is several, about 1, 2, 3, 4, 5 pages of logs. The logs are from the RTS server, results transmission system, on various days leading up to and after the election date of the 9th. In particular, 15th July 2022 to the 16th of August 2022. And I must apologize to bring the bad news not only to this court, but to the entire Republic, that those logs contain active participation of foreigners on the results transmission systems of IBC from the 15th to the 16th of August, 15th of July to the 16th of August 2022. Their names are Vito, Josio, that is the names identified in these logs, Josio, Ogudino, Sisiva, Provisio, and Jacamargo. The copies I provided to the court are much clearer, and you can see the names, you can see the times, and of interest, and I will only highlight certain entries, only the longest entries. I will start by saying those 6 individuals, foreigners, in the Immigration Act they are also referred to as aliens, accessed this server 180 times or thereabouts. The longest being Camargo on the 8th of August 2022, Josio, let me deal with the time. Josio on the 9th of August 2022, which is the election day, for 1 hour 32 minutes. Ogudino on the 11th of August 2022, 2 hours 54 minutes. Ogudino again on the 11th of August, 3 hours 16 minutes. Ogudino on the 14th of August 2022 for 2 hours. Ogudino on the 4th of August again, 1 hour 57 minutes. And then the 16th of August, Ogudino, 1 hour 1 minute. I close by saying, what a mess, what a mess. My learned friend Mr. Ngati has struggled so hard to get Mr. Camargo out of the mess of taking control of our elections. In the case of the 34A we've just been talking about, but we have caught Mr. Camargo and all his friends in our election process before, after, and where are they? Only God knows, and only the servers will show us. History is repeating itself. 2017, Mr. Chepkati refused to provide access to the servers. He's doing it again. And of course, please, I ask the court to take note of everything we have provided as far as the DCI has provided to us, we have provided to the court. These are individuals whose identities are not even known. They travel on, or they provide expired passports when interrogated by the police, and all the rest of it. I would not repeat any more of that. On the 8th of, yes, I'm happy to be pointed out, the logs will also show that on the 8th of August 2022, Camargo accessed the portal while in Venezuela. So our elections were conducted from Venezuela. The Venezuelans decided who won. Mr. Chepkati was just a mouthpiece. Thank you.
My Lady the Chief Justice, my Lady the Deputy Chief Justice, my lords, my ladies, in the remaining few minutes, permit me to take you through our report from the scrutiny exercise carried out at Forodha. And my lord, I'd like to very quickly just highlight sequentially in the order in which the ruling was made.
Did we get your name for record purposes?
My apologies once again. Jackson Awele is my name, my lady. My lady, in the order in which the ruling was given, order number 5 granted the applicants inspection, scrutiny, and recount in respect of 45 polling stations. There were about 16 polling centers, and within them we had 45 polling stations. Now, in conducting the exercise, our focus was on qualitative aspects of the results and the electoral materials that were deposited in the ballot boxes. And one of the things, if I may start from where Mr. Mahat left from, that we were looking out for were the QR codes of the KIMS kit in tamper-proof envelopes and KIMS validation form 44 in tamper-proof envelopes. My learned friend, Mr. Mahat, has urged you to go through the scrutiny report, and that in that report you will find information and evidence about the QR codes of all the KIMS kits and in respect of the ballot boxes that were submitted to you. We hate to submit to you, my lords and my ladies, that in your report you will only find one QR code and one KIMS validation form 44 that was submitted or that was found in the ballot boxes that were submitted for scrutiny out of the 45 polling stations that we scrutinized. Of all the other ballot boxes, the QR code of KIMS kits in tamper-proof envelopes and the KIMS validation forms, Form 44 in tamper-proof envelopes were missing. The question is, where were they? In light of Ms. Soweto's submissions, your guess is as good as mine. We also looked for the pasted carbon copy of Form 34A in the ballot box, and in all the forms, or rather the ballot boxes, we didn't, or rather the book 2 of Form 34A was only found in 27 out of, were not found in 27 out of 45 polling stations. And as a matter of fact, my lords and my ladies, if I had time, I would go through the list, but this represents 50% of the ballot boxes that were submitted to us for scrutiny, missing book 2 of Form 34A. Now, in Vita Primary School, the other electoral material that we looked for was the Form 32A that evidenced voting by using the manual register. In Vita Primary School, Station 7 of 7, 232 people we noted voted using the manual register, and no Form 32A was submitted in respect of those votes. In Vita Primary Polling Station 1 of 7, 260 people voted using the manual register. No Form 32A was availed to verify that indeed the authorizations that the IEBC stated should be given before voting by manual register were indeed given. Finally, my lords and my ladies, in respect of the Form 34A, the carbon copy of the result that went out. My time has run out, my lord. If I may just make that point in 1 minute, with your kind permission. We noted that in the 27 polling stations, in the 27 polling stations that we noted did not have book 2 of Form 34A, they also did not return the carbon copy of the actual results emanating from those polling stations in the ballot box. In other words, the results or the ballot papers in those ballot boxes could not be verified with the carbon copy of the original Form 34A that was used to declare the results in respect of those polling stations in these presidential elections. For those and all the submissions made by my learned seniors and Mr. Murgo, my lord, I thank you for your time and pray that the petition be allowed to spread.
May it please your leadership, the Honorable Chief Justice and distinguished members of the Supreme Court. My name is Njomo. I do appear for the third petitioner, who was originally petition number 2 before in the consolidated petition. Your leadership, I'll make a brief comment on the report of scrutiny, and I'll focus on the scrutiny that happened at the Forodha House, and my learned friend Njoki Mboshe will focus on the scrutiny at the IEBC offices at Anniversary Towers. Your leadership, we have looked at the report as a result of the scrutiny, and we have isolated some few issues that will urge the court to consider in perusing the report. And one of the notable issues, and I concur with what my learned friend Mr. Awele has observed, is that we came across in a process that I personally participated in what learned Judge Justice Njoki has observed, that it is a process that took more than 24 hours. We came across ballot boxes that did not have original or carbon copies of Form 34As. Your leadership, the effect of that is that the authenticity of the forms appearing in the public portal is then called to question. There are ballot boxes, for instance, I'll give the Mikindani Primary School, polling station number 8 of 9, the report is appearing at page 81, where it is clearly observed that it did not have the Form 34A. We also have another polling station, that is Chepkulung Primary School, 3 of 3, that did not have the Form 34A in the box. So that then the question arises, where is the source, or what is the authenticity of the Form 34A that is displayed in the portal? Because there is nothing to compare with as required by the regulation. Another notable issue that we came across, your leadership, is that there were ballot boxes that did not have seals matching what is recorded in the polling station diary. My lady, what happens is that at the close of polling, one is required to record the seals that are then affixed on the ballot boxes when they are closed, so that the record of the ballot seals as appearing in the polling station diary, when they don't match what is actually presented to the court at the point of scrutiny, that raises eyebrows. Because it happened in one primary school, you note your leadership from the report, at paragraph, page 53, Majengo Primary School, it's observed that in the report that all the serial numbers had been altered. The effect of this, your leadership, is that we cannot then be sure at what point is the ballot box opened, so that those seals that were affixed at the close of the polling were changed. Alteration of seals is a serious breach of the regulations that govern elections. Your leadership, another observation we made on the broken seals is with respect to Keheo Primary School in a constituency called Ojorok in Nyandarua County. What the report by the registrar of this Supreme Court notes is that the aperture, this is where the ballot paper is slotted in, putting in the box, had a seal that had been replaced. The seal that was noted at the close of polling and the seal number on the aperture at the point of scrutiny had been altered. This is noted, your lordship, my lady, at page 146 of that report that is before the court. The third issue that we also noted is as regards Book 2 of 2. My lady, the Chief Justice and distinguished judges, Book 2 of 2 needs to be put in context. That the IEBC printed Book 1 and Book 2 of Form 34As. When that was discovered, the IBC indicated that Book 2 of 2 will not be used for purposes of reporting presidential elections. But then the assurance that the IEBC gave was that that Book 2 of 2 will be deposited in the ballot boxes and it will not be utilized. Unfortunately, at the point of scrutiny, there were 27 polling stations from the 45, or rather 47 that were to be scrutinized that did not have Book 2 of 2. The question then that begs our minds is, where did the Book 2s of 2 go? Were they used to report results, presidential elections, or where did they vanish to? Because the factual position is that those Book 2 of 2s were missing in at least 27 of the polling stations that went through scrutiny in the process that we undertook. My lady, another issue, and the honorable judges, that we came across is that there were missing counterfoils from the ballot boxes. The requirement under the regulations is that when a ballot is slit from the main booklet, then at least a counterfoil will remain. The purpose of scrutiny will then serve some purpose if you compare the counterfoils against the number of votes that were cast, including the rejected votes. But, my lady, the Chief Justice and judges of the Supreme Court, without the counterfoil being present that you can compare with, then a question then arises. as to whether those who are actually the ballots appearing in the ballot boxes were torn from the booklet, because there's nothing to compare with. Counterfoils were missing, my lady and honorable judges, from Keheo Primary School. This is noted at page 146 of the report. From Keheo Primary School, polling station number 2 of 2. My lady, there were myriad of issues that we came across. In addition to that, with the scrutiny, envelopes, electoral material, these include the ballots that have been cast, the counterfoils that have been used, the register in the polling station, all those electoral materials that the regulations require that they should be deposited in the ballot box in tamper-proof envelopes. But unfortunately, what we came across was that there were very many polling stations from the ones that we undertook scrutiny where all the contents, the electoral material, were not placed in tamper-proof envelopes. And just to give an example of a few, we had Muvita Primary School in Mombasa, that this is noted at page 34 of the report. Polling station, also Muvita Primary School polling station 7 of 7, there were 7 polling stations. That happened also in Mikindani Primary School, polling station number 7 of 9. This is noted at page 80 of the report. We have Chepkutung Primary School, polling station number 1 of 3. We have Kapsusel Primary School, polling station 1 of 3. That you find in the ballot box, the materials are there, but they are not placed in tamper-proof envelopes as required by the law. Your Leadership, we look at those anomalies in line with the provisions of the Elections General Regulations of 2017, and specifically regulation number 81, that require this electoral material to be placed in tamper-proof envelopes and then sealed in a ballot box. When that happens, it is a clear breach of the regulations as required. And then these anomalies, again, it is my humble submissions that I also speak to the requirements on the Article 86D of the Constitution. And my lady, this is clear because it requires electoral system to be accountable, and even requires the IEBC to preserve electoral material in a safe manner. When this has not been done, Your Leadership and honorable judges of the Supreme Court, we submit that that is a clear breach of the Constitution, and no accountability can then arise in the event where such issues have arisen. My lady, having spent my minutes on the issue of scrutiny at Forodha, I'll now hand over the floor to my learned friend Joaquim Bosche to comment on the scrutiny of the technology process. Thank you very much and appreciate. Thank you.
My Lady, the Chief Justice, Honorable Judges of the Supreme Court, I noticed that the time was still running as I was walking here. I hope I'll recover my seconds. As my learned brother has indicated, I'll be going through briefly what happened at Anniversary Towers. Just to add that, my lady, we have already seen the gaps from what my brother Mr. Njomo has said. The breaches, the illegalities, and the gaps that were there in the collection, the tallying of the numbers. My lady, what we have been told by the first and second respondents, as you will see it happening even as we went to Anniversary Towers, is the attitude of get over it, it's over. Because, my lady, and as has been ably submitted by my learned senior Mr. Mugor, when he was talking about what happened at Anniversary Towers, we were denied access to the server. Our agents were denied access to the server. My lady, and honorable members of the court, when you retire, you will see at page 8 of the report, item number 4, that they said the best they could do was to give us a clone image of the server. When we said, let's proceed, or when our agent said, let's proceed, it became clear that to generate a forensic image, the there was the requirement for the development of what is called a forensic image hash. My ladies, honorable members of the court, it was then asked for the IBC because they wanted to give us this clone to generate the hash. What did they say? They said, oh no, the judiciary should generate the hash. Yet, it is the system that they are calling upon us and Kenyans to believe they were in control of. They have no idea how to generate those things, and if they do, they want to take zero responsibility for that job. And that is why, contrary to the requirements of the Constitution, the IEBC abrogated their duty to conduct the IT component of the election and gave it entirely to Smartmatic. And that is why Smartmatic wrote a letter further to the directions of this court, that letter was served upon our firm yesterday. And the letter is dated 31st August. On the right, and this letter should be before this court because it is addressed to the registrar. So I expect Judge, honorable members of this court, that it's before you. Clearly, it shows it is from Amsterdam. And it says that they will not give us access to the servers because it infringes on their intellectual property. What Mr. Macharia called today, the question of what happens to our data? We cannot even verify the election, contrary to the requirements of the Constitution that it should be verifiable. When the Honorable Court gives orders for scrutiny, Smartmatic says they cannot give us that access. We have set it out. It's set out in the report that has been placed before this court, and the letter is there to confirm. What they then go ahead and do is to amend the orders of this court. And my ladies will see when you read that letter that they say that instead they would like to recommend that the IEBC makes available, and they say the documents that they want IEBC to give us, including some system logs, which, as Mr. Murgor has indicated, not all those system logs were provided anyway. And the ones that were provided, we saw who had access. Our agents did indicate that when we asked, because this becomes very important on the question of access, and that's why the logs become important as well, when we asked, as the court had directed in its ruling, order number 1, that we get a password policy, they said no, it will infringe on the security. And that becomes extremely important in terms of knowing who had access to those servers, in terms of confirming the the code or the policy on change of passwords. They refused to give that information. Again, IBC refused to give us information with respect to the RTS, Results Transformation Systems. Yet they want us to come here and believe what they are telling us with regards to the contents of the portal. Yet in their own gazette notices, as you will find, there were some points where there was human intervention, and that is why they are unable to explain to this court, which we asked them to do and they were unable to do, to explain how the JPEG photos, my ladies, 2 more minutes? Thank you. They are unable to explain how an image is taken but ends up on the server as a PDF. In their own gazette notice of 3rd August, which is part of our evidence, the petitioner in 002, they said that in some certain areas, returning officers will be allowed to take photos using their phones and transmit the same to the tallying center. So how then is it that all the photos on the portal are in PDF, and yet they refused, they declined and dishonored this court's order to give us information on the results transmission system? My ladies, my lords, will find when you look at the report that has been submitted, page 11, the judiciary report, that They refused to comply with orders number 1. They refused to comply with orders number 4. They partly complied with order number 3 and number 4. Honorable members of this court, the ICT scrutiny was anchored on those 4 orders. They therefore failed to comply. They refused to open the server. Smartmatic wrote, and to the best of what they could tell us, in addition to amending